Hi everybody, welcome back. I'd like to conclude this part of the course by talking about the application of the Coase theorem in situations where transactions costs are low. As we've seen, when transactions costs are low, property rights will ultimately gravitate to their highest valuing owner through free exchange if necessary, and therefore an efficient allocation of property rights will be reached regardless of their initial placement. But as we've seen, the initial placement of the property rights does make a difference as to how the maximized value of property rights is divided amongst all the individuals who own them. So, when transactions costs are low, the Coase theorem applies, and the effect of the initial placement of new property rights is purely distributional. And in such a case, we're frequently forced to confront Judge Posner's critique of using the courts to assign rights so as to achieve justice. You'll recall that Posner argued that justice was a subjective concept, something that could not be reduced to propositions of logic, and that therefore different people could have different conceptions of justice, including judges, and these different conceptions of justice may lead different judges to decide the same case differently, or the same judge to decide similar cases differently depending on the identity of the parties and the judge's feelings as to how the equities or fairness aspects of the case should in fact be decided. Posner's critique is that if judges are going to use property right disputes so as to do justice, they run the risk of violating the rule of law. I'd like to illustrate these propositions and talk about them in the context of an especially poignant case that concerns one of the most important historical events of the 20th century. That, of course, was the Reverend Dr. Martin Luther King delivering his famous "I Have a Dream" speech at the rally at the Lincoln Memorial in Washington, D.C. on the 28th of August, 1963. King delivered this speech to about 250,000 people, and it made a tremendous impression on the American public at the time. It was a historic speech. It moved millions of people, myself included, and as an important historical event, it has some economic value. King was up much of the night before he gave that speech, working on the wording, but it wasn't, in fact, the first time that he delivered a speech in which he used that trope, the "I have a dream" trope. 2 months earlier in Detroit, he'd given a speech where he used much the same language, as it were, trying out the ideas that he immortalized in the August 28th speech, and that Detroit speech was recorded as well. And King, after the August 28th speech, sold the rights to the recording of the June speech in Detroit to Motown Records so that Motown could sell a copy of the speech as a record, with the proceeds from the sales of the records donated to Dr. King's organization, the Southern Christian Leadership Conference. So on August 28th, when King gave the speech, there were 250,000 people hearing it, and some of them, after King gave the speech, caught it. Obviously, somebody filmed it. That's where I have the film clip to show you to illustrate the speech itself. But other people were there with microphones, and they too caught the speech on their microphone and recorded it. One of them was a record company named Mr. Maestro Incorporated, and Maestro, as we'll call him, Maestro recorded the speech, and very shortly after it was made, Maestro released a record on sale at local record stores. Indeed, I remember it being for sale at the record store that I used to frequent when I was a boy in Chicago. But Dr. King had never given his permission to Mr. Maestro to record the speech and to sell it, and this despite the fact that Dr. King had not, at least at the moment that Maestro recorded the speech, King had not registered the speech with the Copyright Office in Washington, and so did not own a formal copyright to the speech. So King decided to sue Mr. Maestro so as to enjoin the publication of the record. That is to say, to stop Mr. Maestro from producing and selling the record without King's permission that would presumably come if Maestro could purchase that permission from Dr. King himself. So we have some litigation, a case called King versus Mr. Maestro. It was decided in the Southern District of New York, a federal district trial court, later in 1963, in December of 1963. So let's talk a little bit about King versus Mr. Maestro, the litigation concerning the ownership of the speech that Dr. King gave at the Lincoln Memorial in August of 1963. Notice what's at stake here, what the object to which people are claiming property rights actually is. It's not simply a speech. It's not simply words that could be spoken by anyone. I could, for example, read the speech into a microphone and have it recorded, but nobody would purchase such a record because I'm nobody with respect to this speech, and the important aspect of the speech is not necessarily just the words themselves, but the entirety of the event, the emotional character of the event, the historical nature of the gathering itself in the context of the civil rights movement. The words spoken by this particular man on this particular occasion in this particular way is what is the powerful event. And so what they're claiming, both sides in this case, are claiming property rights not just in the thing called the speech or in the particular words of the speech, but they're claiming ownership in an important sense in the historical event itself. Dr. King claims exclusive rights to the speech, by which he means only he can decide who may use the speech for profit. He can stop, if he is granted these exclusive rights, Dr. King can stop Maestro from publishing the speech in the way that it has, and he can ask Maestro, if it wishes to publish the speech, to negotiate with Dr. King and to pay him an acceptable sum of money to secure King's permission to publish the speech. Maestro, on the other hand, does not claim exclusive rights to the speech. It certainly couldn't plausibly claim that the speech belonged to it rather than belonging to Dr. King, who wrote the speech and actually delivered it at an event in which he had a large part in producing. Maestro instead claims that the speech was given by King as a public performance on the day it was given in Washington, and that therefore the speech was put by King at the moment of delivery in the public domain. What this means is that everyone has the same right to use the speech for profit, presumably in any way that they wish, without coming to terms with the person who wrote or delivered the speech. So King claims exclusive rights to use the speech for profit. Maestro claims, on the other hand, that the speech is in the public domain, and therefore that anybody has a right to use the speech for profit. One interesting aspect of the case is contained in the language that we use to talk about the event itself. In English, for example, we are accustomed to saying that Dr. King gave the speech. And indeed, that's exactly what Mr. Maestro would like the court to decide in this case, that King gave the speech away when he delivered it, and that since he gave it away, Maestro was there to receive it, and now it is able to use the speech in the way that it chooses in order to earn a profit for itself. But that's a peculiarity of the English language. If we compare that, say, to the German language, we get a slightly different result. In German, one would say that Dr. King held the speech, which suggests, in fact, that he didn't give it away, but that he produced it for other people, but that he held on to it while he was producing it. And indeed, that's what Dr. King would like the court to decide in this particular case, that the speech was a public event, to be sure, but it was not a public event in which Dr. King gave away the contents of his speech and the economic value of his speech to anybody in the audience who was there to receive it and able to hear it. So the question before the court, and the one that we'll be talking about here, is whether indeed King gave the speech or whether he held it, and indeed whether he gave the speech to some people but not to other people. So, who owns the speech? My mother and father, who were working on the day that the speech was given, only saw a little bit of the speech that evening when they came home from work, because they sat down and they watched the CBS Evening News with Walter Cronkite, who was then the most beloved newsman in the United States. CBS, the sponsor or the producer of the CBS Evening News with Walter Cronkite, is a profit-making corporation. They're a news medium, that is, they're there to perform a distinctly political function in the United States, which is to help people to keep current on public events, to hear the news, and to help them formulate their own opinions on public events. Nonetheless, CBS does not produce the news for free or as a public service. It does so in order to make money. And many millions of people watched Walter Cronkite talk about Dr. King's speech in his evening news broadcast on August the 28th, 1963. And Walter Cronkite, indeed that's how we'll refer to CBS, Cronkite did not come to terms with King either. Cronkite did not buy King's permission to use the speech on his evening news program, but Dr. King did not sue Cronkite and try to prevent Cronkite from making a profit through the use of the speech in the way that King sued Mr. Maestro in an attempt to keep Maestro from profiting from the use of the speech. So, does this mean that the news media, Cronkite, have a right to use the speech, even if King did not receive any compensation from Cronkite for Cronkite's use of the speech? One point might be that, of course, Cronkite's coverage of the event was favorable. Indeed, everybody's coverage of the event was favorable because it was such, indeed, an emotionally powerful and uplifting event. And so, King, portrayed on the evening news, became, as it were, a more beloved national figure as a result of this speech than he had been before the speech. The favorable coverage, as it were, amounted to very favorable publicity for King, for his movement, and for the ideas that his movement represented. So one might argue that given this favorable coverage and the free publicity that King and his movement received from Cronkite's coverage of the speech, that there might be implied consent to the use. That is, since the favorable coverage was obviously to King's own advantage, then that advantage may produce an implicit act of consent on the part of King for Cronkite to use the film clip of the speech without compensation. But if that's the case, it raises the question of what would happen if the coverage were unfavorable, or if the event itself were somehow embarrassing to the people who were portrayed, or even shameful to the people who were portrayed. Now, the situation would be the opposite of favorable coverage. It would be embarrassing coverage that would perhaps subject the person covered or the person depicted in the news report to ridicule or worse. In that case, there's no question of advantage to the person whose image or words are being used by the news media, but indeed, there is, again, no question of consent required, no question that Walter needs to come to terms with people whose activities or words are portrayed on the television or on the radio in an unfavorable way. An alternative view of who owns the speech might simply see Cronkite and the news media as agents of some larger body, the people of the United States themselves, who, it might be said, have an overriding First Amendment right to see and hear the speech because it's a public event, because it's important in the political aspects or the political activity of the United States, and that people have a First Amendment right to see important newsworthy events as they happen, and therefore, in order to vindicate that right, Cronkite can be seen as their agent. Despite the fact that he makes a profit, agents frequently do make profits for their activities. In this view, Cronkite is merely the intermediary serving to transfer a property right from King to the people themselves who have the overriding right to use the speech. But if Cronkite can be a profit-making agent so as to enable Americans to hear the speech, why should Maestro be denied a similar role? Maestro, after all, is disseminating the speech in much the same way that Cronkite did. Maestro is charging for the use of the speech, that is, people must buy the record, but Cronkite too charges advertisers to put his program on the air. And so it's hard to distinguish Maestro from Cronkite if the issue in the case is whether the people themselves have the right to use the speech as part of their First Amendment rights. In either case, however, it's not clear in this case why the news media should have the right, or the public should have the right, for free. It's not clear why the law, that is, should allow Cronkite or the public to use the speech for their own purposes without compensating King. After all, CBS has to pay all of its other content providers for what they contribute to the programming of CBS and thus to the profits of CBS. And so the question might be raised, this is not really entertainment, it's news, but nonetheless, it's quite an effort to put on a march on Washington and to produce a speech before 250,000 people. A good deal of money must have been spent in order to do this, and King and his organization presumably bear the costs of producing the event. Thus, when Cronkite or the public use the event for their own purposes, they're not only using King's speech, but they are essentially free riding on King's expenditure in order to produce the speech. And so the question then arises, why not simply force the news media or force the public to purchase the speech from King in the same way that King is asking Maestro to purchase the speech from him. Okay? So, this does appear to be a Coase theorem case. In the first instance, there's no question of incentives to produce in this case. Typically, in the case of copyrights, copyrights are legal rights awarded to people like King precisely to prevent people like Mr. Maestro from using the intellectual creations of people like Martin Luther King for their own profit or benefit without coming to terms with the producer of the artistic or literary creation. The typical justification or rationale for copyright, that is, for allowing artists or creators or publishers to maintain the right to stop other people from using their works without their permission, is that it is costly to produce works of art, and if people believe that their work can be freely appropriated, then they may not produce that work at all. And therefore, if their property is not protected and people are able to freely use the artistic or intellectual creations of others, the incentive that those others have to produce those creations will be substantially reduced. But there's really no question of this sort of thing happening in Dr. King's case. No one suggests that Dr. King would not have written or delivered the speech had he known that Maestro would record the speech and attempt to sell it. King didn't write the speech for money, he wrote it for other purposes, and he clearly did not have the money-making potential of the speech in mind as he was writing it and as he was delivering it. So, indeed, copyright is not a circumstance here where we have to give the copyright to King, otherwise we won't get the speech itself. Moreover, transactions costs in this case are quite low. King knows who Mr. Maestro is. There were 2 or 3 other defendants in the case. Fox Movietone News was one of them, and King knew who all of them were. He knew them well enough to sue them, and so presumably he knew them well enough to be able to negotiate with them, should there in fact be something to negotiate. So indeed, if the right were given to King, then it would be relatively easy for Maestro or Fox Movietone News or even for Walter Cronkite to negotiate with King to purchase King's rights to the speech and therefore to produce or portray the speech themselves now with King's permission. So, in this circumstance, where there are no allocational issues presented with respect to incentives, and where the transactions costs separating King from the maestros of the world are relatively low, the Coase theorem applies. That is, whether King is given the right or Maestro is given the right, King and Maestro can presumably come to some sort of agreement to move the property right, if necessary, from a lower valuing owner to a higher valuing owner. In such a circumstance as we've seen, the law's decision is purely distributional. It turns on the question of who the judge believes deserves the right to this particular historical event and the economic value that it creates more. In the real case, the court decided the case for Dr. King. And indeed, it did so in large measure, I believe, because Dr. King was such a sympathetic figure. He had not, in fact, registered the speech in the Copyright Office, and indeed, there were other people who were listening to the speech and who were using it for their own purposes, in addition to Mr. Maestro, despite the fact that they weren't using it commercially so as to make an economic profit. So the court decided the case for Dr. King, even though it was, as the lawyers say, a case close to one of first impression. That is, there was no precedent which covered this particular case exactly, and so the court felt comfortable in awarding the copyright to Dr. King, I think because he was such a sympathetic figure in this particular case. But this poses Judge Posner's critique of doing justice through the law rather sharply. Consider the case with a slightly different set of facts to see if you'd come up with the same result. Now the speaker is not a beloved, sympathetic figure like Dr. Martin Luther King, but just the opposite, a universally despised figure, the Chancellor of Germany from 1933 to 1935, Adolf Hitler. Suppose the speech in question were not a speech by Dr. King in front of the Lincoln Memorial, but a speech by Hitler at a Nuremberg party rally in 1935 or 1936, and suppose the German equivalent of Mr. Maestro had recorded the speech and attempted to sell records, perhaps in the United States, to warn Americans of the danger that was emanating from Germany. Would we decide the case in the same way? Would we say that Hitler had the right to bar Mr. Maestro from earning a profit on Hitler's speech? Would we allow the news media to transmit Hitler's speech? Would we prohibit the news media from transmitting Hitler's speech? Generally, would the case be decided differently if the plaintiff were not nearly as sympathetic a figure as Martin Luther King? If we obey the rule of law, that is to say, if we decide similar cases similarly, these two cases are similar enough, I think, to warrant a decision in favor of Hitler's ownership of the property rights in the same way that King was awarded ownership of the property rights in the actual case. But it may well be that our lack of sympathy for Hitler causes us not to have much sympathy for his claims to be the only one able to earn profit from his speech, and so perhaps on these grounds that Hitler was a bad man, we might grant the property right to Mr. Maestro and not require Maestro to share whatever profits it earns from the speech with the originator of the speech. But if we did that, we would then become the judges that Posner has warned us against. We'd have taken similar cases, which are distinguished only because our feeling about the fairness or the equities in the case, and we will have decided those cases differently on the basis of our evaluation of the fairness or equity of the case. And if we do so, just as Judge Posner suggests, the rule of law is threatened.